All right, good afternoon, everybody. This is June 22nd, 1:30. We're doing a legislative overview of some of the outcomes of our last legislative session. I know a lot of you who are on here were at our conference at the end of May when we went over some of these things, but this is just a time for folks who couldn't attend that conference or for us to get into maybe some more details on some bills that we didn't discuss there. There were a lot of great presentations there. And I'll start off by showing you where you can get resources from that conference if you weren't able to attend or if you want to go back and see some of the presentations you saw there. So I'm going to share my screen briefly here. I think if you all are seeing that, that takes you, that's our homepage for our TCSA webpage. And if you go to the events tab here and then scroll over to the Spring Legislative Conference, that will take just a second, but then it'll pull up here links and connections to a lot of our conference handouts and presentations that were there. So you see there's some for the legal issues for highway class, personnel policies. Then when we get into our general sessions, the first one there is from Crystal Ivy on the broadband updates, and then they go on down from there. You'll also see we were able to record some of the sessions and have like a YouTube video specifically of the county about the opioid abatement funding and solutions that you may pursue there. So that's all available out on the website. And then I'm going to, right here, just above the abatement solutions, you'll see there's a link to TCSA 2023 legislative session results. That was a handout we had at the conference that we'll be working off of that mostly today as we talk about things. So you can access it there if you weren't at the conference to get it. I'm also going to switch over. This is the University of Tennessee CTAS website, and they have some great resources out there as well. So if you're seeing this one, let me know if we're not on the CTAS website, somebody, but and you go to their tab for reference materials and then click on Index of Acts. Every year, the attorneys at CTAS summarize everything that passed related to county government offices. So you can see their 2023 Index of Acts is up and available. It's broken into 3 sections. Part 1 is public acts that apply generally everywhere. Part 2 is public acts that apply only in certain local jurisdictions. And then Part 3 are private acts. And you can see then it's broken out by a lot of different topics. So you can see things related to alcoholic beverages, county clerks, court clerks, so on and so forth. If you click on any of those, then it opens up and shows you the things that are there. Their summaries are only going to include bills that actually did pass. Our handout, which I'll be working off of today, it covers a mix of both some bills that we were working on or watching and monitoring that did pass, as well as some that didn't as well. So we will go ahead and kind of jump right in on that then. And but before we get much further, I will just say, if you all can, keep our folks at the legislature in your thoughts and prayers right now. There has been some kind of a scare at the legislature, and the building is locked down, as I understand it. Charlie Curtis isn't able to join us here in our office because he's over there being quarantined, but there were some packages or some mail that was delivered at the General Assembly with suspicious substances in it. And so there have been some breaking news alerts here that the building is currently on lockdown, I believe, as they're trying to investigate that and make sure that it's not anything dangerous going on. So keep those folks in your mind. We're going to just run through these kind of alphabetically, and I'm mostly going to talk about, or not alphabetically, but kind of as they appear numerically in the document. And I'm mostly going to talk about just things that were enacted. But if as we're going, you want to type questions into the chat about some things that we don't cover, if we don't discuss a bill that didn't pass, we can talk about that some as well, or answer any questions. The first one that's listed in here under county government just happened to be one of the earliest bills that passed. This relates to the cap on the size of Metro Council. If you've watched much news, you've seen there have been a number of different pieces of legislation this year that were involving really Metro Nashville to a large degree that the General Assembly was pursuing, and some of those are caught up in litigation right now. This one in particular, though, does apply to set a cap on the size of Metro councils for any government that goes to a Metro form of government, and it sets that limit at 20. The other 2 metropolitan councils or metropolitan governments in Tennessee, Moore and Trousdale County, they already were not over 20 members, so this really only impacted Metro Nashville. They are currently going through their election this year because of their charter, they're 1 year behind. So it has 40 members. When this legislation passed, there was then legislation filed by Nashville that got an injunction to say it would not apply in this year's election because of the short time frame that was involved. But this will, as it stands right now, take effect on the next legislative or next election for Metro Council members in Davidson County. So that one is out there and did pass. The second one really relates to those public officials like a county mayor or a county commissioner who may be involved in performing marriages. You are able to receive a gratuity if someone offers that for the service of performing a marriage, but this legislation prohibits you from requiring them to pay a fee or to pay something in advance. You can't charge a standard amount to perform marriages. You aren't required to perform marriages, but if you choose to do so, you can't charge for that. You could accept a gratuity, but you can't charge. So jumping on down, one of the next items that's on here, item number 6, towards the bottom of the page, prohibits local governments from financially supporting abortions. As this legislation was moving, an amendment was added on to clarify the fact that this applies to expending funds for a criminal abortion. So for instance, you could not, if you're a local government, provide some sort of benefit to employees to pay for them to travel to another state or to go pursue getting a procedure done if that procedure is criminal under Tennessee law. If it's, as was discussed to some extent this year about some of the abortion prohibitions, if you have there are certain procedures that may take effect if a woman has had a miscarriage and needs to have certain things done that would technically fall into the definition of an abortion. If that's something that our law does allow as a medical exception, then like counties that are self-insured, for example, it would not be a violation for them to fund that, but you could not provide benefits for someone to pursue an illegal abortion. Item 7 is another prohibition on local government that says cities and counties cannot adopt or enforce regulations that require a private employer to do more things with regard to hours for their workers or to provide a higher minimum wage, for example, or things like that, anything that is in excess of state or federal laws. 8 I'll mention is one just kind of an interesting thing that came up. This passed the House. It has not passed the Senate. As it was originally introduced, it was going to require flying of both the U.S. and the state flags on all property owned, operated, or controlled by the state or a political subdivision of the state. We asked for some clarity on that, and an amendment was added in the House to adjust this bill because nobody's opposed to the idea of flying the flag on actual public facilities, but as this was originally filed, it was any property owned, operated, or controlled by a political subdivision of the state. So that would have meant if you went out and bought 50 acres of vacant land for the purpose of building a school on in the future, you would have had to start flying a flag on that right away. I know the sponsors were happy to work with us on that one and get the language corrected a little bit. I said it hadn't passed the Senate, it did pass the House, so that bill may get completed next year when they come back. Moving on to the next page here. Early on in the legislative session, we had actually Representative Hicks approach us about this bill number 9 related to industrial development boards. And he had found out that there were some places actually kind of not in compliant with the current law. Some of our industrial development boards had people serving on them who were not residents and voters in the county or city that created that industrial development board. In particular, he mentioned one where they had a rural county in his area where there was I think an industrial recruiter who did a lot of work with the industrial development board that was serving on it, but he actually lived in a neighboring county. So he asked us if we would have any concerns about lifting that residency requirement, and we did not. And anyway, he pursued that and that went forward. So that lifts that restriction on requiring residency and gives you a little bit more flexibility on who can serve on an industrial development board. And like I said, hopefully it fixes some issues for places that were not currently in compliance. Number 11, with regard to officials, number 11 on officials' retirement, and employees' retirement as well. There are certain options you have under the Tennessee Consolidated Retirement System where a city or county can vote to enhance the benefits that are provided to their employees. Under current law, when a local government decides to do that, they either have to pay a lump sum to cover any kind of unfunded liability that will cause, or they will see an increase in their employer contribution rate starting in the year after they adopt that additional enhanced benefit. This was a bill brought at the request of the state treasurer's office, and it actually now adds a third option for the local government to have that unfunded liability spread out and amortized over a 10-year period, or up to a 10-year period. So that creates some more flexibility if you have a county that is wanting to enhance some of their benefits under retirement systems, but don't want to get hit up front with a huge unfunded liability. 12 is something related to officials' bonds that's really only going to be significant when we have our next election. As a sort of a matter of a quirk in the law, these bonds that our officials are required to enter into generally have, under current law, they had to have been approved by the county commission before they took effect. So in many cases, you would have officials elected in August. They were going to take office on September 1. They would go and get their bonds. And it might be the second or third week in the month of September before the county commission meets to actually act and approve those bonds. The problem with that is that there was also statutes on the books that said that an official is violating the law if they take any official action prior to their bond being approved. So you had this window that maybe 2 or 3 weeks where technically officials were needing to be operating their offices, but if their bond hadn't been officially approved by the county commission, they technically were violating the law. So the approach under this, it had to go in and amend a lot of individual statutes for each office, but really it's just to remove that requirement that the bonds be approved by the county commission prior to them being able to take effect. It retains the ability of a county commission to request and require a higher than the statutory minimum bond for any particular office. But like I said, this eliminates that step of having the county commission approve the bonds prior to them taking effect, so that hopefully everybody can get their bond acquired prior to September 1. And so that office is immediately covered on 12:01 after midnight on September 1st. A lot of offices that wouldn't be as significant, but for an office like the sheriff, if they are not covered and bonded right there in the first few hours of their term, there's potential that they could run into liability. Many offices across the state and many counties are now covered under insurance. That was an alternative that was passed several years ago. So they have insurance to cover malfeasance or inappropriate actions by the official, and they use that in lieu of a bond. But particularly with trustees that tend to have higher bonds, a lot of trustees across the state are still under a bond rather than insurance. All right. Moving into education, a few things we'll throw out there. The first item number 13, relates to education savings account, or also known as private school vouchers. As you all remember, in 2019, that legislation passed at the General Assembly, and at that time only applied to Davidson and Shelby counties. This bill this year was brought originally by particularly a senator out of Hamilton County who wanted to expand to add his county into the program. As the bill was moving through the House, at one point it had been amended to add in Knox County as well, but there was a disagreement between House and Senate on that. When that amendment came over, the Senate did not agree in it. And so I think the sponsors or parties involved negotiated. And as the legislation passed, it only added Hamilton County into that program. It did not add Knox. So starting for the 23-24 academic year, those ESA programs will be available in Davidson, Shelby, and Hamilton County. Skipping down to item 15 on the bottom of this page, summer learning camps. Summer learning camps were enacted back in 2021 during a special session related to education, specifically on education and learning loss that was occurring during COVID. So back then at that time, the legislation that passed required that there would be summer learning camps and after-school mini camps during the summers of 21 and 22 for certain priority students in certain grades. It was grades 1 through 5. There was also a required implementation of learning loss bridge camps for students entering grades 6 through 8 for 2 of those academic years, and then in grades 4 through 8 in subsequent years. This legislation basically is kind of taking some of the limits as far as the timeframes and as extending those camps indefinitely. It's going to allow some additional students. So students entering kindergarten through grade 3 can participate. It's also adding in 9th grade students into this. And this program is funded really entirely out of state sources. There are 2 different pots of money that they are tapping into, actually 3, for the after school learning mini camps. Those are being funded 1/3 out of state TANF funds, and then the remainder of the costs are being funded out of the Lottery for Education after school program reserve funds. So that's estimated to cost somewhere in the neighborhood of $8.6 million to run those after school learning camps. And those 2 pots of state funding are being used for that. For the summer learning camps, it's got a larger price tag on it. It's more about $30 million. But again, they're using TANF funds to cover about 1/3 of that. And then the remainder is coming from a general fund appropriation from the state. So for the most part, the things to understand about that is that they are extending these camps to run further beyond the timeframes that were originally set during COVID. And they have expanded some of the students that are eligible for that and the class grades that are eligible for that as well. All right. Moving on to the next item, item 16, school security. Obviously, a lot of things arose with regard to school security. Some of this legislation was moving prior to the Covenant school shooting, which occurred in Nashville. And then the governor and the General Assembly responded with additional appropriations through their budget with more funding and more programs for that after that tragic shooting occurred in March of this last year, or of this year. But this bill, which is Senate Bill 274, House Bill 322, passed with regard to school security and school security plans. One of the things it's doing is it is moving the state level school safety team from the Department of Education over into the Department of Safety. That hopefully will provide more clear coordination with safety and homeland security in those offices and the functions that they play in help preventing violence in schools. It is requiring school systems to review any safety plans they have on an annual basis. And then so for school systems as well as charter schools, they need to provide both their district-wide school safety plan, their school building level safety plan, as well as the floor plans for all their school buildings and facilities to both the Department of Safety and also the local law enforcement. Those things are also all made a confidential record, so they are not subject to public records for obvious reasons. You wouldn't want someone who potentially wanted to commit an act of violence against a school to be able to access that school's safety plan. So it requires those plans be shared with different entities. The bill also updates some requirements for required drills, both armed intruder drills, incident command drills, and also school bus safety drills for emergency situations surrounding school buses. There is a requirement in the bill as well that every LEA is to ensure that all exterior doors to a school building are locked with limited access into that building. It authorizes local law enforcement on, to pop up and do inspections to determine whether or not that school is complying and keeping the exterior doors locked as they're supposed to. If an officer does an inspection and finds that there's non-compliance, they're required to report that to certain parties, including the State Department of Safety, but also the principal, the director of schools, I think the chair of the school board as well. So they report that finding. If there have been multiple findings of a school being out of compliance with the requirement to keep their doors properly locked and secured, it starts kicking in a series of penalties. The first level is that if you do not have an SRO or an armed school security officer present on that campus, the school system is going to be required to do that. And since they are not properly keeping their facility locked, if there continue to be found additional violations of the security requirements for keeping the doors locked, this can trigger for the State Department of Education to withhold funds. And it would be not to the entire system, but for that specific school building. And it begins, the penalties start with like a 2% reduction in the funds that school building would normally generate in state funds. it can go all the way up to a 10% fine if they continue to have violations. And I think the cap is after 7 violations, that school system would see a 10% withholding of their state funding. Now, as soon as they come back into compliance and they follow a corrective action plan and get everything in place, that funding will be restored. But it's the General Assembly was serious about saying that the first line of defense with our schools and our students is to make sure that the entrances are properly locked and secured. So they were very serious about what they wanted to see done with regard to school security. I'll pause here for a second and also talk about the SRO grants, as I mentioned, that were something that were funded in the state's budget. There was roughly $140 million added in right there at the end of the session to the governor's budget to fund SRO grants. And those are available roughly on a $75,000 per school amount for each recognized public school in the state. So I've switched over here. This is the Department of Safety and Homeland Security's website. If you go to their homepage, actually, the SRO grant thing should pop up right here as a right on the front page, and that takes you to this page here. This is where they're posting information about that grant program. There are over here on the left, you'll see some frequently asked questions about it that go through the specifics of what you can and can't use the funding for. There is also a list here of the schools that are recognized by county. So I would encourage you, if you haven't already, take a look at your county and see. I mean, you can jump to anyone on here. Here's Hawkins County, and it's got the list of all the recognized public schools in the Hawkins County school system. If your county has a school on these lists, then that school is going to be eligible for the $75,000 SRO grant, and that will be regardless of whether you're currently providing an officer or not. And what was in the budget as it passed, and what the Department of Safety is saying, is that if you already provide an SRO, you can use this funding to fund an additional position within that school, or you can use this funding to cover the cost of the current SRO that you've already got in place and free up that local money to be used for other purposes. So if, let me get it back to the page about the basic information. So I said there's the FAQs, there's the list of the schools that are eligible for each county, so you can know how many your county is entitled to receive funding for. And then if you go on down here, there is I think it's a 10 or 11 page MOU that the law enforcement agency is going to have with the school system in order to qualify for this grant. So the grant will actually be given to the law enforcement agency. So the sheriff's department, for example, if the county sheriff is providing the SROs, it could be a municipal law enforcement agency if they are doing it. But there's a draft of the memorandum of understanding you have to have there in place. And then there's also an application form you can click on. So I want to make sure you were aware of that. Like I said, there's a little bit additional information beyond what we had at the May conference. But basically the understanding is we have Bryce Allen as the Deputy Commissioner of Homeland Security was at the conference. And as he talked about it, it's that $75,000 can be used for salary, for benefits, but also for equipment and other ancillary costs related to providing the SRO. If, like, for instance, you're buying a vehicle for that officer or providing maintenance for it. So he felt like really, even though probably the SRO salary and benefits won't eat up the entire $75,000, with some of the additional uses you can spend the money on, most counties should be able to use that $75,000 per position to cover all the costs related to providing the SRO. So I'm going to pause here for a second. Carol, do we have questions up in the chat? I want to check before we get too much further into it. Stop sharing for a second so that I can.
Yeah, I don't see any. I had the chat box open and I haven't seen any.
Okay. All right. I said, if you come up as we're going, I may not notice it right off, but yeah, just pop a question in the chat if you've got something that you're wanting to discuss. So let me jump back over to where we were. Hopefully you're seeing the page up again with the various summaries of legislation. Item 17 that's on this page, the teacher salary schedule. This is a change that's going to kick in over the next 4 years. This was something discussed last year as the legislature was debating changing to the new TISA funding formula. An element of TISA provides that when the General Assembly provides increases in education funding, particularly in the base for each student under TISA, they can earmark a portion of that to go towards required salary increases for existing teachers. When they do that, the State Department of Education is then instructed to recommend and make changes into the salary schedule for how teachers are paid, specifically to the minimum step. So what we had this last year, that minimum salary schedule had a base salary of $40,000, which would apply to a brand new teacher with 0 years experience and a basic college degree. There are steps within that if you have additional years of experience, it's not every year, but it's like, I think at year 5 and year 10, as well as if you get more advanced degrees, a master's degree, a doctorate degree, the teacher is entitled to additional pay. So I said that minimum salary schedule step was at $40,000 for this year. This legislation moves that to $42,000 for the upcoming school year. Then the proposal is to go to $44,500 for the following year, $47,000 for the year after that, and then $50,000 for the 26-27 school year. The analysis of this for the fiscal notes on the legislation, and then also the analysis that the State Department of Education has done, they are telling us that the additional funding that school systems are receiving through the enhanced funding in TISA should cover the cost of these required salary increases. That was stated on the House floor when the bill was passed. That was, I said, we had meetings with the administration, with the Department of Education, and they assured us that that funding was there and that they've done that analysis. I've mentioned this before when we've talked about education funding. If you are looking at the funds you are getting under TISA and taking a look at the cost of what these future salary increases are going to be, and it does not look like this is going to cover that, we need to hear that from you so that we can share that back with the department. Because I said that's their indication to us, is they're saying, look, yes, we're going to require these increases to keep our pay scale competitive so that we can recruit and retain good teachers in Tennessee. And they're saying that this additional state funding should cover that. If you're hearing otherwise, we need to please let us know. The next item, item 18, again, back to school security. This was legislation that was brought to authorize a local law enforcement agency to be able to enter into a contract with a private school to provide an SRO. There was a jurisdiction in the state that was looking at doing that with a private school in their community, and they were told that legally they didn't have the authority to do so. So this was brought by Representative Faison in the House, forget the Senate sponsor, but this legislation was moving forward, and I believe it even passed prior to the Covenant School shooting. I think it certainly would have gone forward after that, even if it hadn't passed previously, but that was already in the works prior to this occurring. All right. Switching on down, kind of one of the last items we'll cover on education is a new requirement, item 23 regarding maternity leave, and this requires LEAs to provide the licensed educational employees of the school system 6 paid work weeks after either the birth or stillbirth of an employee's child or the employee's adoption of a newly placed minor child. The state is required to reimburse the LEA the cost of that paid leave, and that was funded in the state budget. But that's a new maternity leave benefit for school employees, for teachers. Moving to elections, there were a number of things that came up with regard to election that didn't pass. Some that were going to require all local elections to be partisan. One that was going to set a process to set term limits on local offices. But those, like I said, did not pass. But one thing that did pass the House and is expected to move forward in the Senate next year is this item 27, HJR 13, on the timing of county elections. This is requiring a constitutional change, so it's a long process. To amend the Constitution in Tennessee, you have to have a resolution which passes both the House and Senate by a simple majority in one legislative session. Then they'll come back in the subsequent legislative session, not just the next year, but the next legislative session. And it has to pass both chambers by a 2/3 majority. Then it will be sent to the voters to in a referendum for them to vote upon on the ballot. But what this proposal would do is to change the schedule for county elections from having a May primary in those counties that have primaries and an August general election to move to an August primary and a November general election, which would align with the state elections for state house, state senate, and the governor. Everything would run at the same time. This has the potential to save money and reducing elections by eliminating the May elections in most counties. But obviously it's making a change as well to how county offices, the timing of when you take office. So if this moves to an August and November, obviously the county official's term is not going to start in September. It would begin presumably December 1st. So this moved forward and passed the House this year. It happened kind of late in the session, and the Senate did not act on it to pass it this year, but is expected to next year. So that's something, like I said, it'll go through a long process, because then we would have to come back to the next General Assembly and see it pass again, and then have it go to the voters. But if there are thoughts or concerns you've got about either pro or con with this proposal and these changes, let us know as this comes forward and we see it again next year. EMS, something that passed here that's hopefully going to help local governments maybe keep some of their EMS workers. There have been some training supplements that are paid by the state for law enforcement and firefighters. This is a new legislation that will give a licensed Tennessee ambulance service with full-time emergency medical services personnel the potential for an $800 a year stipend that's paid to those personnel for completing their required training. I said this is something similar to training benefits and supplements that have been paid for law enforcement and firefighters, but it's now expanded to emergency medical services. There was this next item, you can see item 29, was trying to enhance the TennCare reimbursement for ambulance service. But that bill was referred to committee but didn't really move this year. That's something that may come back again next year, as we're trying to see improved funding for ambulance services. Under environment, the main one we've got here is this bill became public chapter 86 with regard to brownfields. It was a Governor Lee administration bill that is setting up a new brownfield redevelopment fund to be used by TDEC to assist with really was aimed to a large degree at like former industrial sites that need cleanup before they can be really used again. So it creates both a franchise and excise tax credit that can be used for qualified projects in tier 3 and tier 4 counties. That would be more of our economically depressed counties or at-risk counties. But that's out there, and it's a new state program. If you've got facilities or properties that you know of in your county that you'd like to see cleaned up and put to good, this is a new grant program that's available for that. All right, under firefighters, there was a legislation passed that's been something that we're working on for several years to create a presumption that if a firefighter gets diagnosed with PTSD, that there would be an assumption that it does relate to something involved with what they were doing in their line of duty. There's difficulty in the past of this being something that a firefighter might have PTSD.
Yes, with the fact that they didn't surprise and a cover.
To prove what that was, what the cause of it was. There are actually grant funds available as well through the state to assist in paying the cost of any kind of increased workers' compensation for that. But that was something that several legislators have worked on for a number of years. I'll mention item 32. This is something that did not pass, but we definitely think there is, will be back next year. And that is a discussion of related to growth plans or comprehensive growth plans, urban growth boundaries, rural areas, planned growth areas, all of that. The bill as originally filed was going to just delete all of that, but talking with the sponsors are saying, well, that wasn't really the full intent. We just started off with a bill in that form to kind of see where we're going to go. The bill moved forward in committees somewhat this year, and there's discussion about where they wanted to go with that to make changes, and then the bills were deferred until 2024. But we're expecting to see that return back again next year with legislation to make some kind of changes with regard to growth plans and annexation. As they started talking about the bill, they got more into some things with regard to extraterritorial planning and zoning that were kind of outside where the bill was originally filed. So they may move in that direction next year, but we will keep an eye on that. See, kind of also in the area of land use planning and zoning and codes. You may have seen some national articles and news about efforts in certain states or at the federal level to ban certain types of appliances in homes. So there was legislation this year that passed, this item number 34, Public Chapter 45, that prohibits local cities and counties from passing an ordinance or a regulation. Basically, usually the talk has been around natural gas appliances. So cities and counties in Tennessee can't ban certain types of appliances in residential homes based upon the type of energy that they use. And really, like I said, we're talking about natural gas appliances. The next item, item 35, that starts here and carries over. This is really something probably mostly that urban areas would have an interest in. It did pass both chambers. This doesn't have the public chapter number on it, but it would be assigned by now. But it creates an option. And I said, really, we think this is looking at some of the major construction projects going on in Nashville, where a local government can vote to accept independent electrical inspections by an electrical engineer if there are times, and it's really to help with some of the backlog you might see on construction projects, so that if the local government's inspectors themselves are having a hard time keeping up with that or dealing with really large scale complex projects, an inspection can be done by an electrical engineer if the local government agrees to accept that type of inspection. Moving on to the next item, item 36, energy conservation standards. This was something we heard about from the Home Builders Association. They had concerns that some of the pending rules for building codes in the future, specifically their energy conservation standards in those, were going to be really difficult and expensive to comply with. And so this provision was saying that local governments can't adopt energy conservation codes that are more stringent than what the state minimum standard is. So the state minimum standard is kind of set where we've got the basic codes now and don't include some of these really enhanced provisions that are coming in future building code updates. So this is saying that local governments cannot adopt a standard that is more strict than what the state has on the books. Shifting over to law enforcement, item 37 about suits against deputies. There are a number of different provisions in the laws with regard to sheriffs and sheriff's deputies that provided different options for an individual to bring a suit for an injury caused by either the sheriff or the deputy. This one particular provision had some greater flexibility on the ability to bring actions against the county. The Sheriff's Association was working on this legislation to really add some parameters around it to make it closer to the Governmental Tort Liability Act. So there's a requirement now that any kind of such action has to be filed within a year of when the cause of action occurred. And the county has a presumption that if they don't answer the complaint within a certain period of time, it's assumed that the county is denying the factual allegations of the complaint. Also under law enforcement, item 38 here with regard to constables, this was a new provision that was included to say that a person seeking the office of constable is supposed to file with their county election commission a letter from a licensed psychologist who is saying that they have examined the person and that they are free from any kind of mental or cognitive defects that could make them unfit to perform the duty of constable. Item 39 is one that we've already heard a fair amount about, and we're going to try to work with some folks and come back and see if we can have some recommendations maybe on creating a little bit more flexibility on this item. This legislation started off saying that any prisoner who was allowed out of a county workhouse or jail on work release had to be wearing an ankle bracelet at all times. I know the Sheriff's Association worked with the sponsors on this to get an amendment added, which would say that the requirement for the ankle bracelet does not apply so long as the the prisoner is out and being supervised by an armed officer and remains in that officer's direct line of sight. We began kind of hearing back quickly from some mayors and sheriffs as well that they had concerns that this is going to cause a significant amount of cost. Like, for instance, if you're bringing a low-level offender out, that they do some routine maintenance, or they may mow the property at certain facilities, they may do different things. That's not always supervised, especially by an armed officer. Many times correctional officers do not carry weapons on them. So this is something we'll stay in contact with the Sheriff's Association and discuss. Obviously, it was being brought to help protect public safety. There being a concern that an inmate who might be out on work release gets out of custody and they lose track of where they are, and they might commit additional violent offenses. So the thought is that this was trying to help monitor them. So we may see if we can come back with some additional flexibility specifically for some of the county work release programs where they're doing work for the county itself. If they're going out on work release to work for a private employer, that employer has to pay the cost of the monitoring device, not the county. Item 40 was another piece of legislation that was brought to kind of help with some of the difficulty that law enforcement agencies are having with keeping fully staffed up. A lot of law enforcement agencies are dealing with a lot of vacancies. So this creates some additional flexibility for people who've gone through retirement from a law enforcement agency, but they want to come back and continue to provide work. So they've shortened the window in there to where, as long as you have been retired for a period of 60 days, you can now return and begin working in law enforcement again. During that reemployment period, you'll see down here that the benefit is reduced to 70% of what their retirement would have been eligible to receive. It does not add to their benefit, and there's some provisions about how this additional liability might be funded. But it does create flexibility for those retired officers if they're wanting to come back, and the agency wants them to come back and do some additional work after retirement to help alleviate some of the difficulties in keeping law enforcement agencies fully staffed. Item 41 was an interesting one we saw moving during the legislative session. It prohibits state and local agencies from purchasing a drone that was produced by a manufacturer that is now banned under the National Defense Authorization Act of 2019. This I hadn't heard of before, but apparently the federal act that passed in 2019 prohibited government agencies from using drones. Primarily, I think these are Chinese manufacturers that were found to have been, or at least there was suspicion that they were transmitting information back to the Chinese government. It does not require you to get rid of any drones if you've got some currently right now that have been bought from one of those companies. But for any contracts or agreements entered into after July 1 of this year, you can no longer buy from companies on that list. So if you have drones from that company and they fall out of service, you're going to have to replace them with a drone from a different company that is not banned under this Defense Authorization Act. All right, also related to electronic monitoring of inmates, item 43 here was a bill that came out of a study committee that was put together last summer. The Electronic Monitoring Indigency Fund is a fund that the state administers, which helps pay some of the cost for indigent defendants of those types of various ankle bracelets. It originally started with ignition interlock devices for DUI offenders. So there's been funds that are available to help defray part of the cost of that for indigent defendants. That fund traditionally is always running through a lot more money than is generated by the fines and fees that fund it. So one of the recommendations that came out of that is that we needed to separate out the funding for ignition interlock devices related to DUI offenses from all these other types of monitoring. So ankle bracelets, there's also transdermal monitoring for drug and alcohol offenders and things like that. So this is implementing a number of recommendations that came out of that study committee. The first one was to divide the funds up so that we don't have the intermingling of GPS monitoring devices being pulling out some of the money that was going to fund DUI interlock devices. So they're in two separate accounts now. As things have been set up for a while, local governments that want to participate in drawing down some of these state funds to pay for like the ankle bracelets and things like that are required to put in some local funds towards that as well. That would continue. But this is also adding in that an indigent defendant, one of the things that really the legislators wanted is that we need to make sure they've got some skin in the game as well. So the indigent defendant is required to pay a minimum of $30 a month towards it as well. So you're going to get some funding from the state, some from the locals, and then some from the defendant. This also, one of the things the study committee found was that it varied a great deal from jurisdiction to jurisdiction, whether or not the judges were taking a hard look at who was indigent. So you had some jurisdictions that were small in population that might be using 3-4 times as much of this funding as a neighboring jurisdiction that might be a lot larger. So this was requiring some greater scrutiny and some criteria for judges in determining who does qualify as indigent. There was a concern that a lot of places the judge was basically just saying everybody qualified, and that was causing them to draw down a lot higher funds than you would have expected. Something that came out of a couple of legislators in Northeast Tennessee, this bill, Senate Bill 927, House Bill 1484. This provides that for inmates in county facilities that are HIV positive, the medical costs for providing prescriptions and medication for those individuals is really expensive. So this is saying if state or federal funds are available for that purpose, the county is relieved of the responsibility of paying for that medication, and you can use state and federal funds instead. As a general rule, counties are just on the hook for providing medical care for any kind of inmates that are in their custody. But this is one case where it's like if there are state or federal funds available, those can be used to pay the cost for HIV patients that are in the facility, and it relieves the county of that responsibility. Moving on to the next page, open meetings. There are a couple of different things that happened here with regard to open meetings. These have both generated a number of questions since the session happened. The first one, item 46 here, notice of meetings, Senate Bill 27, House Bill 23. As the legislation started, it was going to involve a lot more requirements on local government as far as a county or city, either one, having to provide basically make copies available on hand for any request of all materials provided to the county commission, for example, for any meeting. So if you have copies of the budget materials, if you have extensive reports, anything you had, every meeting you were going to have to produce and have copies on hand of all of the extra copies of all those materials, just in the event that someone requested them. As we talked with the sponsors about this, they're like, yeah, that's going to end up driving up a lot of cost. In many cases, you'd be producing these reports and nobody's asked for them. Well, we worked with the opponents. It was coming from some of the press and open government groups to where it was narrowed down in the end that this basically applies to city councils and county commissions to say that you need to make your agenda for meetings available in advance, at least 48 hours prior to the meeting. You can comply with this by putting it on your county website, or if you don't have it on a website, you just need to make sure that the copies of the agenda are available in a publicly accessible building at least 48 hours in advance of your meeting. You are not prohibited from bringing up new business at the meeting, so long as that's in compliance with part of your local rules. But it did include a provision that you can't use that new business requirement to basically leave controversial items off a meeting agenda and then just bring it up under new business to avoid people knowing that it's coming on. So you can still bring up new business as long as it legitimately is new business. Otherwise, you're supposed to include notice at least 48 hours in advance of your meeting what your agenda is for that meeting. Most counties are already in compliance with this and been doing it for a while, but this was something that's brought by kind of the Press Association, some open government groups, and as it's been narrowed down, that's really the main requirement is posting your agenda 48 hours in advance. This item right across from it, item number 49, public comment at meetings. This has actually kind of generated a lot of questions. This requires governmental entities to provide a period of public comment at any public meetings that would fall under the open meetings law. Again, most counties are already in compliance on this, at least with regard to a lot of their meetings. This does still retain the ability of the governing body or the open government or the governing body to make determinations about restrictions on that. So you can set a maximum amount of time for public comment. You can set when it is. You can set the length of time. that an individual speaker can talk. You can set a cap on the total number of speakers. It does state in here that this would be people wanting to comment on items that are actually on the agenda for the meeting. So you can't just have somebody who's disgruntled show up wanting to rant about things that don't have anything to do with the agenda for your county commission meeting. So it can be related to the items on the county commission meeting. You can set time limits and limitations on the number of speakers, and it also includes that you can require them to sign up in advance if they're wanting to comment. So they need to let you know in advance that they're wanting to comment, not just showing up at the meeting. So that's out there. Like I said, there's been a number of counties, and I think they've been talking with CTAS a lot, as well as some county commissions that have been looking to adopt rules on how they're going to do this. They were doing it maybe on a more informal basis beforehand, but that is a new requirement with regard to open meetings. Under opioids, there was an amendment to the bill that passed 2 years ago about how we're going to distribute and share the opioid settlement money coming into the state. This did not make any changes to that. So there's still a certain percentage of the funds, 15% coming to a local government, local subdivision bucket to be shared among local governments. Then there's 15% goes to the state, and the remainder, the other 70% goes to the Opioid Abatement Council. Out of those funds, 35% of that money is reserved to go directly to counties, and that money started flowing. This doesn't change anything about that formula for distribution, but we have seen additional settlements happen. So there are more companies now paying money into the state. The original bill that acted only applied it to just certain specific counties or certain specific settlements. So this was expanding that to add in these new settlements so that they fall into the same distribution formula. Pause again just to see. Not seeing some questions. Under taxation, the administration had the Tennessee Works Act that was providing a number of different tax breaks and tax benefits out of mostly state tax sources. Some of it does impact local governments, but the state was holding us harmless. One of the big items is a 3-month grocery tax holiday, which is going to start on August 1st and run until October 31st. There are provisions that were already on the books when the state enacts these sales tax holidays that direct the Commissioner of Revenue to hold local governments harmless. So basically what happens is these retailers don't collect the sales tax on these qualifying purchases during that time period, but they still report the sales to the Department of Revenue. The State Department of Revenue calculates what the local option sales tax would have been had these been eligible for taxation, and the state is actually funding the local, continuing to provide the local governments with what that local option sales tax would have been. So that protects us under the sales tax holiday. There are also some cuts and some reductions where certain small businesses would not qualify or are no longer going to be required to file business tax. So it creates some exemptions there. There were adjustments in the bill where the Department of Revenue was estimating how much they think that might reduce collections of business tax at local government level. And they adjusted for this by enhancing the amount of the share of the business tax is split between the state and local governments, and they basically adjust that percentage so that more money flows to local governments. So they think that's going to offset any losses here from these small businesses being granted exemptions. But that's hopefully providing some good tax relief to our families and small businesses in Tennessee without impacting local revenue. Item 52 gets into the online like sports betting taxes, the fantasy sports betting, that kind of thing. Those funds, there's a small percentage of that do come to local governments. They have been designated where that money was earmarked and could be used for capital projects only. This expanded that to say you can also use it for funding for emergency services. It tends to fluctuate, so I would, just as a recommendation, say probably ought to look at using that for capital expenses rather than ongoing recurring expenses, but that's additional flexibility on how those funds can be used. In the area of property taxes, and we're getting near the end of this, there are a few changes that occurred that are significant. Item 55 was a comptroller's office bill that was doing away with the Assessment Appeals Commission that had kind of been an intermediate level of property tax review that they feel like is no longer necessary. So they were eliminating that. We think that'll streamline the property appeal process. Item 57 on here related to business personal property taxes is a shift that came out of a TASER study. So the Tennessee Advisory Commission on Intergovernmental Relations looked over the last year at ways to make it easier for both businesses and for local governments to process and handle and comply with business personal property tax requirements. So businesses have been required to provide a schedule every year that itemizes all of their business personal property, unless they had an option, if you're a very small business, of saying that we have $1,000 or less. So they could check that box and say, I'll pay the appropriate taxes on what $1,000 worth of personal property would be, but I'm not going to file the detailed schedule. What TASER's recommendation was to raise that and to increase or add in an additional step. So what this legislation does is it allows a small business to report that they think they have $2,000 or less, or there's a new category of $10,000 or less. That's going to eliminate a huge number of the business personal property tax returns that have to be filed, which will make things easier for the assessors of property, but it also helps with compliance. A lot of businesses came in and testified that if you're a small business, the amount you spent on actually either doing these inventories yourself or hiring an accountant to do it far outweighed the amount of taxes that were paid. So in some cases, you might have them spending hundreds or thousands of dollars getting an accountant to pull these returns together to pay $12 in business personal property tax, that kind of thing. So we participated in this and trying to help with the negotiations and work out the end product, but think this overall is going to help possibly with better compliance on business personal property tax. Also definitely create some administrative relief for those small businesses and then make things easier for the assessor's office as well. Bringing up the assessors at item 58 here, Senate Bill 397, House Bill 33. This is a bill that provides some flexibility in cases where there's been a presidentially declared disaster. Those obviously happen pretty frequently in Tennessee between tornadoes and wildfires and floods and other items. In the past, the legislature has usually enacted something specific to an individual occurrence to say that the assessor can provide some flexibility and relief to property owners whose property was damaged or destroyed as a result of that natural disaster, to give them a break on their property taxes and prorate it for the period of time their property was either before it was replaced or repaired. Instead of filing another one of these each year for whatever disasters and tornadoes may happen this year, this basically puts it on the books and says this is available to counties or cities anytime they want to enact it. It requires, you'll see here, a 2/3 vote of the county legislative body for to apply in a county. But that often, most times we see counties do that. If a community in their county has been hit by a tornado or other major natural disaster, they will authorize the assessor to provide some prorated relief to that property tax payer, because obviously they did not enjoy the benefit of their property for the entire year while it was damaged. Item 59 is another property tax adjustment which dealt with Greenbelt, and it was clarifying that land can qualify as agricultural land when it has been enrolled in certain land conservation programs. I think there was an example of some property that technically did not qualify under Greenbelt because of the definitions, but it had clearly been put into a conservation easement where it's going to be maintained as open space. So this was kind of clarifying and fixing that. Item 60 is something that relates to the property tax freeze. So you have some different property tax relief programs out there. Some are funded by the state that are provided to low-income elderly and 100% disabled veterans. Then there's also the optional property tax freeze program that counties can opt into, which about, I think, 1/3 of the counties have. When they do that, there is an income limit as far as who qualifies for that in terms of seniors. And current law, it's based upon the average median household income for senior citizens or whatever the income limit is for state property tax relief. This gives you a third option. So a community can say, we're going to raise that limit all the way up to $60,000, but that would be at the vote of the the county itself would have to adopt that higher rate, but they can do that if they need to. This was brought by some legislators out of Davidson County, I think, trying to assist seniors in the Nashville area with really significant increases they've seen in property values and how that affects their taxes. Right. We have had discussion, obviously, at our meetings, from Commissioner Ely and others. We've done a session on here before about the Transportation Modernization Act. That was, obviously one of the highlights of the legislative session. Provided $300 million in one-time funds for state aid funds to county highway departments. Also was transferring $3 billion from the general fund surplus of the state budget into the Department of Transportation. That money is available to be spent, $750 million in each of the 4 TDOT regions. It did a lot of things as well, as far as authorizing choice lanes, some new alternative delivery systems for TDOT. And then the other big item helping local governments is that it enacted some ongoing increased fees on electric vehicles and hybrid vehicles, which is intended to help kind of equalize things out so that those vehicles are paying a comparable amount of taxes towards the transportation system that a traditional combustion engine vehicle does. So those fees are in there, and local governments are included so that we share in those in the same manner as we do in fuel taxes. That was a huge thank you to the General Assembly, but the administration as well. We met early on with Commissioner Ely, and he immediately argued that case to the governor, and they agreed to say, yeah, we should allow these EV fees to be shared with local governments the same way gas tax is. So we hope that's going to stabilize some revenue sources for county highway departments going forward, and offset some of the losses that we're seeing in gas taxes. On to the last page, nearing the end, item 65. This isn't going to affect a lot of folks, but highway departments may need to be aware of this, that there were some new requirements if you are transporting logs or pulpwood. Mostly this is going to affect the logging industry. New requirements for strobe lights and marking and flags on those, just for traffic safety reasons. Under utilities, item 66 there, this is a minor thing with regard to the Underground Utility Board. It made an adjustment in the number of members that serve on the executive committee of that board. County highway departments do have an interest in the operations of that board overall, so we're including it for that reason. And then item 67 was some changes in the utility oversight boards within the comptroller's office. They merged the Water and Wastewater Financing Board and the Utility Management Review Board into one new entity called the Tennessee Board of Utility Regulation. Also in this legislation, it included a new grant fund and funding for to help encourage the consolidation and merger of utility systems. So there is some grant funding available for that if that's something being considered in your community. All right. A little over the hour, but we've kind of run through that. I'm looking to see, there was one question early on about brownfields. That act, as I understand, does only apply to the tier 3 and tier 4 counties, so more economically distressed counties. But that's a run through of a lot. Sorry to ramble on for so long, but cover some of the top issues that we saw moving through the General Assembly this year. As mentioned at the start of this, if anybody joined later in the process, this handout's available on our tncounties.org website under the events tab for the resources that were provided at the legislative conference. And then also I'll switch back over to the CTAS and show you real quick. If you go to CTAS's homepage and go to reference materials and then the index of acts, they summarize every year, and they've got them online all the way back to 1995, all the legislation that passed this year relative to county governments that impacts them. So if you hear about legislation or you think you've heard about legislation and you're looking for it and how it might affect counties, you can get all that information there on the CTAS website. So don't see any other questions in the chat. If anybody wants to unmute and jump in, feel free to. Otherwise, we appreciate you joining us today. And forward to seeing you again soon.